by SLU Employment Law Professor Marcia McCormick. Hi, Marcia. How are you?
Hi, I'm great. Thanks.
Thanks for coming in. We asked you to join us here today because of a ruling by a judge in New York about a couple of interns who worked for a movie studio called Fox Searchlight Pictures, and they were interns who were unpaid. I know a little bit about this because my daughter is a college student who just did an unpaid internship this past semester. And I said, see if you can find a paid internship for the fall just to help our personal bottom line here.
Right.
Are you familiar with this case?
Yes, I am.
Okay, so what are your thoughts on unpaid versus paid internships?
Well, unpaid internships run the risk of violating a federal law called the Fair Labor Standards Act, which requires that if you work, you get paid minimum wage. There are a few exceptions to that. So if a person is working solely for their own benefit, so if they're volunteering for a nonprofit, if they're a student who is really just learning about an industry, then they're not considered an employee. But other than that, you're an employee, you should get paid.
Okay. In this case, the judge said, hey, you know what? These interns were doing things like answering the phone and arranging people's travel plans and tracking purchase orders and taking lunch orders and taking out the trash and putting together office furniture. That doesn't sound like you're being trained for your future career. That seems like, hey, we hired you to do grunt work and we're not going to pay you for it.
That's exactly right. And there are a lot of industries that are sort of notorious for those kinds of internships where really what they're doing is hiring people for scut work, but saying essentially, you know, this is your way into our industry. It's the only way into our industry, so you should do it for free.
Of course, the industry would say, hey, at least you're inside the industry. Your foot is in the door. You're going to make valuable contacts here, and that's worth something.
That's exactly right. And that's what the defendant was saying in this case. They were saying, well, now you can list this on your resume. You've made some networking connections. This is going to help you get a job.
Okay, so where do you draw the line? How do you draw the line?
The different courts do different things, but the bottom line essentially is that if this is work that the employer needs for its bottom line, and if this is not something that the potential employee or intern really is getting the absolute most out of, then you have an employee, not an intern.
Sounds very subjective.
It's subjective in the sense that different people can look at the facts in different ways, but the Department of Labor has a sort of 6-part test that you can use to try and get at it a little more specifically, and it's a test that was originally set out by the Supreme Court.
Okay, so why was this movie studio not following that test?
Because in part, in order for people to follow the law, somebody has to enforce it, and the Department of Labor up until about just a little less than 10 years ago, wasn't really paying much attention to these kinds of things. And companies weren't using interns in this way until about 92.
Okay. Oh, really?
Yes.
Wow. I'm pretty sure I had interns working for me in the radio business in the 80s, and they were doing all sorts of grunt work, and I look back on it now and I go, oh, I'm really sorry we made you do that. But you know what? We told them, at least you're getting college credit.
Right. And it's the number of those kinds of internships. So they existed before the 90s, but they exploded in about 92.
Yeah, I know now as a tuition-paying father that you're getting college credit means your parents are paying for you to work for me.
Exactly.
It's even worse than the other way around. It's not only that you're not making money, you're paying me for the privilege of taking out my trash.
That's exactly right.
Okay, so we have lots of people working in lots of businesses now in this country, not just in the showbiz-related fields, but in lots and lots of places. In law, there are people who work in law offices, and how does this apply to them?
Well, it applies exactly the same way, unless you're a government entity or a nonprofit. And the rules are slightly more flexible for those entities.
I'm not surprised to find that the law does not include government entities. You mean politicians wrote themselves out of another law?
Shocking, isn't it?
All right. Now, what implication does this have for, I guess my basic question here is, does this only apply to this employer, or is this now essentially the basis of internship law across the country, and what would the implications of that be for everybody?
Well, it applies most clearly in New York, and not just for this employer, but anybody else who might be affected by the court in New York. It depending on what happens when this is appealed, and it will be appealed, it will likely apply all over what's called the Second Circuit, which is the East Coast, essentially. And the rules really aren't that different for other courts. They use slightly different tests, but ultimately, under any test, this would have failed.
Have there been previous lawsuits like this? Interns saying, hey, you know what? You abused me. You didn't use me.
Yes, there have been, and there have been a few that have been brought by the Department of Labor as well.
Okay, and those never went anywhere?
Well, a lot of them did. They weren't exactly in the same context. They might have involved volunteers or students working for their own school or something like that.
If you were advising a firm that uses interns now, what would you tell them?
I would tell them that if you are receiving immediate benefits from the work, if they're doing the kind of work that you would hire somebody entry level to do, you should pay them.
Charlie Rose, who's now on the CBS Morning News and also has his own PBS talk show, he had a lawsuit brought by some unpaid interns a few years ago, and I'm sure his lawyers advised him to do this because in the end, he turned around and announced in December that he's going to pay back wages to 189 interns who worked with him over many, many years.
Yeah.
They're each going to get about $1,100 each, which, if they work for him for 10 weeks in a semester, that's like $110 a week. Okay, that's a little bit of money for these people.
Right.
Are we going to see others who are going to be forced into the same thing? Because could we get lawsuits from previous interns?
Well, there is a statute of limitations, and so there is a cutoff to how far back anybody is going to be liable.
But could somebody who was an intern in 2011 end up suing that employer in
Yes.
2014 or 15?
They could, or they could just go to the Department of Labor, and the Department of Labor might decide to bring suit.
Very, very interesting. Thanks for coming in today and explaining all this to me.
Sure, thanks for having me.
Marcia McCormick is an employment law professor at St. Louis University, and it's 7:58 here at the Big 550 KTRS.